morning, everybody. Gabrielle Sullivan from Bradley Allen Love. Delighted to join you this morning to talk all things HR and COVID. I might just start with a little introduction to Bradley Allen Love and to myself before we move into the substance of today. Bradley Allen Love is a Canberra-based law firm. We work across a range of fields, particularly in employment law. We work in the environmental and planning space and do a fair bit of work in business and procurement as well. We look after quite a few local councils across New South Wales, particularly coastal regions, the Midwest, way down to the border. So a big shout out to the people down at Murray, pretty much outside of the Sydney metropolitan area. We're covering pretty much the whole of the west, the southwest and the coast. So we've been looking after local council for decades. We feel well placed to look after the peculiar needs of local government. And today we particularly wanted to talk to HR managers about what's on everybody's mind, because of course COVID creates big challenges for HR. So that's the focus of today. So my name is Gabrielle Sullivan. I'm an accredited specialist by the New South Wales Law Society in employment and industrial law. I've been practicing in the field for far too long, so I feel well placed to speak to these matters on behalf to councils. I tend to be involved up to date. I do a lot of code of conduct reviews and investigations and things like that. Those things have been parked for the moment. We're focusing much more on the kinds of flexibility and frankly termination issues that are arising from COVID. So that's going to be the focus of today's presentation. But just so you should know, Bradley Allen Love, we do have a HR breakfast club for our HR clients. They come in on a monthly basis and we like to chat about things to do with HR. We were proposing to do the same thing remotely for our local council clients this year. We were waiting for the bushfires to subside before we picked up the ball. We've now got COVID to launch us, and so here we are trying to present some material that you might find helpful. So we are proposing this become a more regular forum down the track, and if that's something that you might be interested in, then we'll let you know towards the end of the presentation. We understand the challenges that come with living in rural and remote areas and the access to information that you might have. So let's hope this is the beginning of an ongoing relationship. Before I just move to the presentation proper, I should just point out, like everybody else, I'm learning with remote working and online presentations. If we have any technical issues, don't worry. We are recording the webinar. I do have the PowerPoint to distribute. So one way or another, we'll get the information out to you if there's a problem today. I do have fabulous tech support, but they're remote as well, so we'll do our best. With no further ado, let's take it away. Right. So, what are we going to talk about today? Okay, I've found, I probably should say Bradley Allen Love, obviously being in Canberra, we get questions relating to the Commonwealth, to the territories and also private sector as well as local government. Based on those questions in the last couple of weeks, pretty much the same kind of issues are coming up. So I think it's important for you in local government to recall the framework, the regulatory framework by which you're going to answer a lot of these HR questions. Because the fact is, a lot of the questions coming up are novel. We need to go back to the source, and employment law, that can get a bit tricky. I thought I might just start the session by reminding you of what the framework is from which you will answer your HR questions. After we've worked that out, I want to touch on WHS issues. Then we're going to talk about flexibility issues, obviously working from home, leave, and variations to pay, hours and duties are issues that are exercising most employers' minds at this difficult time. Then we're going to move on to redundancies and termination and the vexed issue of stand down. So those issues that I'm going to talk about, as I said, they're coming not just from local government, but the same issues are troubling the minds of HR people right across sectors and industries. I'm very happy to take questions. I don't come naturally to this online forum. I'd much rather speak to you face to face, and I am very happy to take questions as we go. There is a little bit of tech difficulty with me doing that. The text box for questions is micro. So if I can possibly manage that, I will answer your questions as you go. So you just use your little chat box there to type in. And if I can see it and I can respond to it during the session, I will. If that may not work, I'll have a look at the end of the session and see what the questions are, seeing how much time we've got. I'll try and address those. And at the end of the whole presentation, if there's some enduring themes coming out that I haven't addressed, we'll follow that up after the session. So by all means, try and ask your question. I'll do my best to answer it in this session, but I will say I will run to time out of acknowledging that we all have other things to do as well. So I'll try and finish the session on time at 11 o'clock. So let's just remind ourselves of the framework for employment law decisions in local government. Now, everybody immediately jumps to the award, and that's fine because the local government state award answers a lot of our questions in this field, and you'll hear me refer to it throughout the presentation. But it behoves us to remember a couple of other things here, and that is that at the moment, the legislative backdrop to that award is coming to the fore and is very important. So when we talk about work health and safety obligations, of course, they're not in the award, they're coming out of the legislation. So I'm going to dip into the Work Health and Safety Act very quickly. The Local Government Act has got a little bit to say about some of these things. We need to think about the Industrial Relations Act because that's where the stand down provisions are. The Essential Services Act may come into play. The Public Health Act and the orders made under that are obviously hugely important in this space. That's the legislative framework by which the New South Wales government is regulating movements and gatherings and so on. So that's the source of those orders. And finally, the Fair Work Act that pretty much applies across the country, in large part doesn't apply to New South Wales local government, although there's a couple of residual provisions there regarding notice of termination and adverse action that might come into play later. So I just wanted you to remember, when you pull out the award to answer a lot of these questions, don't forget the legislative framework that sits underneath it. Don't forget, of course, that in addition to the legislation and the award, that all employees, by definition, have a contract of employment that underpins all of this. And that is the case for your senior staff, who obviously have an express contract, but it's also the case for your award-covered employees as well. They do have a common law contract that sits underneath the legislation and the award, and there's some implied terms in that contractual relationship that are helping us to answer some of the questions about when people get paid and when they don't. So I will refer to that during the course of the presentation as well. And finally, in addition to the award, the legislation and the contract, there's some policy considerations that are really strongly coming into play here that may well affect the landscape. Particularly, obviously, JobKeeper that we've all heard about it is a game changer for industries eligible for that payment. As at now, it doesn't apply to New South Wales local government. The devil's in the detail on that, and that bill is before Parliament today, I believe. But as at now, our best intel is that JobKeeper doesn't apply to New South Wales local government. that there's a fair bit of lobbying going on by your unions, the Labor Party and whatnot, to get some sort of analogous type fund happening from the state. That's the New South Wales fund there I've got on the slide. But as at now, that hasn't come into play. Plainly, that is hugely relevant, because if there is a fund to secure continuity of employment, well, that's going to affect how you might otherwise make decisions about leave and stand down and whatnot. But as at now, that doesn't exist. So the other key policy development that I think all HR managers right across the state should be aware of, and probably are, but just in case you're not, the unions and Local Government New South Wales signed a joint statement responding to the coronavirus pandemic on the 20th of March this year. It's been revised. I'll speak to the revised version, but it may well be revised again. But that is not the law. It does not affect the award, but it's a statement of intent as far as those parties are concerned. It should at least provide some guidance for you when you're trying to resolve decisions about HR matters where the award, the legislation or the contract doesn't help you out. So you should at least be aware of it, go and have a read of it. I'm going to dip into that during the course of the presentation. Right, so that's the framework. I said to you I wanted to touch on work health and safety. Now, obviously, people write PhDs on work health and safety. I could spend days and days on it. That's probably not helpful. But for what I thought I would be helpful in just a couple of slides was to try and distill your WHS obligations down to some core obligations. And here they are. Essentially, council has a duty, like every other employer across the country, to ensure, so far as reasonably practicable, the health and safety of council workers while they're at work, to ensure the health and safety of workers whose activities are influenced or directed by council, and the health and safety of other persons. And if you just think about that for a minute, that's a really broad remit. Obviously, council needs to worry about its own workers, but it also needs to make sure that the health and safety of other persons is not put at risk by the conduct of that activities. Other persons, of course, is the public at large. So that's a really broad remit there. As far as the WHS of workers is concerned, the obligation is to protect the health and safety of workers while they're at work. And I know the question that you are going to ask, or you probably already know, is, well, if workers are working at home, are they at work? And therefore, do WHS obligations apply? The answer is yes and yes. So home becomes a place of work, and WHS obligations will apply there. I'm going to tell you how to handle that in a minute. But that's your basic duty. Notice the qualifier there. You have to do that which is reasonably practicable. These are difficult times, and I would expect the regulators and the courts will understand that, and we don't have to do that which is perfect. We have to do that which is reasonably practicable. So that's your basic obligation. I thought it was worth the basic employer obligation. I thought it was worth reminding HR managers that it's not a one-way street, it's a two-way street. Workers have duties under the WHS Acts as well, and that is the workers' basic duty is to take reasonable care of their own safety and the safety of others. They have a duty to comply with reasonable WHS instructions, and they have a duty to cooperate with WHS policies and procedures. So there's a little bit of statutory power there to assist you if you have people being difficult about complying with council's WHS policies or procedures. So that's WHS in one slide. Ambitious, but there you are. How are you going to discharge that duty? Again, in a slide, most of you would be familiar with the basic language of WHS, which is you identify the risk, you assess the risk using the matrices, you control it, and then you review it in an ongoing way. You would have people who know how to do that. Just don't let those concepts go out the window in the flurry. We need to keep the discipline of that mindset. What it would involve discharging the WHS risk as far as corona is concerned, obviously you would want to comply with those public health orders, wouldn't you? And you would be following the recommendations of the health authorities. I've put the websites there. I'm sure you're all very familiar with those websites, but at the very least, all employers right across the country would be expected to comply with those the orders and the recommendations as a matter of discharging their WHS duties. And I'm sure you are, but that's how that should work. Probably just a thought about where we know we've got employees who are particularly vulnerable to COVID because of their health conditions. Well, that might mean we need to give a fair bit of thought about the way they work and the duties that they're performing. Special consideration would need to be applied to those people as a matter of WHS. I said to you, for home-based workplaces, WHS obligations would apply. Just a reminder that council's obliged to do that which is reasonably practicable. What's that? Well, at least some sort of employee self-assessment of the home work setup, where the access points are, egress points, trip hazards, etc. To get some video verification of that, a little bit of a zoom around the home workplace, so HR managers can have a bit of a visual on whether the home-based workplace is safe to a reasonably practicable standard. That's just a little thing you could do. Daily communication is going to be essential, isn't it? So that we're checking in on our workers. If there are any injuries or accidents, then it's not left to go for days before it's discovered. That's sort of basic WHS obligations, and it would be at a very minimum, you'd be making sure your employees who are working from home understand very clearly that they're obliged to report any injuries ASAP, at least for workers' compensation purposes, but it'll also for a WHS point of view, so that you can address that risk and make sure it doesn't happen again. So there's a lot more that could be required, but at a minimum, and I would say you're a public sector employer, you would need to do at least that. This is the standard I would expect for a private sector small business. So for local government, you may well have the resources to go above and beyond that, but at least that. So I won't say much more on WHS. I think there's a lot talked about there. There's Safe Work Australia you can go to if you want to have a look at some more resources, and your WorkSafe Regular in New South Wales. We'll have some more information about that if you need. I wanted to get on though to some issues that have come up through the questions. Some people have sent me questions ahead of time. I'm going to try and tackle those in the course of today, but a lot of them were about working from home. So here's a few questions that we're getting. Do workers have to work from home? A week or so ago, the answer was no. As at now, the answer is, in New South Wales, the answer is yes, unless you cannot work from home. If you go and look at the public health order as at 31st of March, then that explains that. And just for your information, those public health orders are on the New South Wales Health website, the website I gave you on the previous slide. So you want to keep up to date with what those orders actually say, as opposed to what everybody else says they say. You really need to go back to the text of the public health orders and have a look. They're pretty clear, but as at now, the position is that they have to work from home unless they cannot do so. So do they get paid while they're working from home? Well, that's a Relatively straightforward question, yes, because it's a matter of contract. Service earns wages. They're working, they get paid wages. It gets a bit more difficult when you start thinking about, well, what happens if kids are at home, schools are closed, and employees cannot effectively work from home. And I'm sorry, I'm not quite sure where the schools are up to in New South Wales. In ACT, schools are open for limited purposes, but most kids are home, including mine. So what happens if we're supposedly working from home, but we've got kids running around and we can't effectively work from home? That's a question I've had. How does the law deal with that? Well, as a matter of contract law, if I'm not rendering service, then I'm not entitled to wages. The fact that it's not my fault is not really helpful to me or my employer. That's the starting point. As I said, when you address these questions, you need to think about your framework. You start from a contractual base that isn't very helpful, but in the case of local government, your award very much gives you a panoply of options to manage this rather suboptimal work environment. I would direct you to Section 21 and Section 22 of the award if you haven't already been paying careful attention to that. Your award allows a whole range of leave options to be accessed, and I'm going to go through leave in the next slide. So I just wanted to park the point at the moment that as a matter of award, there's sick leave that can be accessed, carers leave, time off in lieu, annual leave, and special leave without pay is all provided for at Section 21 of the award. And there's also flexibility provisions at Section 22 of the award that focus around concepts of productivity and practicality, but basically allow staff to work all sorts of different hours to get the job done. And my feedback from my local government clients to date is that's actually what's happening. So there's plenty of options to manage it. You should slavishly follow the terms of the award if you don't want to have your council held to be in breach of the award. As a matter of policy, as I said, keep your eye on the New South Wales JobKeeper equivalent, if any, that might come to the fore. But as a matter of the joint statement that I referred to, the policy position that Local Government New South Wales and the unions have come to is for 2 weeks paid special leave before the staff member is required to access any other leave. And then once that leave's exhausted, they can apply for special leave with or without pay. So that's, as I said, that's not the law. That's a statement of joint intent of most of member councils and their unions across New South Wales. Again, there's lots of questions about that. You know, there's a big difference between leave with pay and leave without pay. I totally get it. I say keep your eye posted on that policy document as to where the majority seems to be going. But as I said, you're not bound by that policy, and already councils seem to be breaking away from some of the commitments in those policies. So that was working from home. I said to you that I would just explain the leave provisions in the award a bit more. I think that's really helpful, just to unpack that a little bit more. Let's check my time. Okay. So just moving on to leave. Your leave entitlements, as you're probably all very familiar with, as far as sick leave is concerned, local government gets 3 weeks paid per year of service, and that's a cumulative entitlement. You can go and read through the provisions of Section 21 and that A there of the award to cover off eligibility criteria. In addition to sick leave, which is sick leave, of course, being where you're sick, carers leave is entitled for staff to use sick leave to care for somebody else in their household or family who's sick or needs care due to an unexpected emergency. Now, all the questions that you may have about, well, who's part of your household, they're all defined in the award. It's rather protracted. But basically, follow the award. Any disputes about it will go to the Industrial Relations Commission, and there's facility there for the parties to take unpaid leave by agreement in any case. All those provisions apply to your permanents. For your casuals, they're entitled to 2 days unpaid leave per occasion, so they don't lose their job, keep their job open. So that's pretty straightforward, and you probably already know that. I guess one of the questions that we're getting thrown up is, well, hang on, this question of so-called quarantine leave. Well, what happens if the employee's not sick, but they're required to be quarantined? For example, say because they've just come back from overseas. So to answer that question, as a matter of contract, the starting point is, well, hang on, are they working? So they're not sick, they're required to be quarantined. If they're working from home, well, then they're going to get paid. They're rendering service, they get wages. But if they're not working because they can't, not because they're sick, but because it's not a job that lends itself to remote working, then the question is, as a matter of contract, well, why is the quarantine required? Is it to comply with one of the public health orders? Or is it to comply with the employer's WHS directions? There's a subtle shift there. If it's to comply with a government order, then as a matter of contract, that would be unpaid because you're not ready and willing and able to serve. If it's a matter of complying with your employer's WHS direction, it would be paid because you're serving the employer as directed. There's a fine line there. As I said, that's a matter of contract. Your award says nothing about it because nobody's preempted this kind of pandemic leave requirement. I can tell you nationally, in the national systems awards that apply to the bulk of the country, already awards are applications are being made to vary the award, to put in some sort of quarantine leave period that absolutely guarantees employment. In some cases, paid, in some cases is not. But that hasn't happened for the local government state award yet, but I would expect that's imminent. As a matter of policy, the joint statement expects that for that period, which is really only a closed period of a couple of weeks, it would be on paid special leave. So that gives you a little bit of a clue about how to manage that. I thought I'd just remind you about annual leave. I'm getting lots of questions about, well, can I direct them to take annual leave or long service leave? And I want to just unpack special leave a little bit as well. You are constrained by, as far as annual leave is concerned, you must comply with the award provisions regarding annual leave. Clause 21D there says that annual leave can be taken by agreement. Great. That's fine while it's fine. What happens if it's not agreed? Well, then you can only direct employees to take their annual leave where they've got 8 weeks leave accrued, and you have to give 4 weeks notice. So that's not hugely helpful. But there it is. Similarly with long service leave, should be taken on application by the employee. Employers shouldn't unreasonably refuse any such application. There's all sorts of provisions in the Long Service Leave Act in the Long Service Leave Award. Excuse me. There's all sorts of provisions in the award regarding long service leave about taking long service leave at full pay, half pay, double pay, or by agreement. So there's a fair bit of flexibility there with agreement. Where there's no agreement, employers can only direct the employees to take their long service leave once it's 5 years overdue, and again you have to give 4 weeks notice. So again, not terribly helpful if we've got an employee who doesn't agree. All right, I'm just going to finish off on special leave, and then I'm going to go and have a look at my questions. So you'll find annual leave, long service leave, not terribly helpful. Special leave, you've got an interesting provision in your award there that just says the employer may grant special leave with or without pay for unforeseen circumstances. Well, you'd be pretty sure that COVID would fit into that. There's no guidance as to whether it should be with pay or without pay. All the award really tells us is that a period on special leave wouldn't count as service for the purposes of accruing other entitlements. As I said, the joint policy statement preference is that where special leave is accessed, you should be paid. You should be paid special leave unless you're directed to take annual leave or long service leave in accordance with the award. And where casuals are on special leave, the joint statement is that they be paid for 4 weeks. So that's the leave position. I'm just going to pause just for a little minute there. I'm going to see if I can check my questions. Let you all have a little glass of water. I'm sorry, I'm actually having a little bit of trouble seeing the questions. I'll have my tech assistant, Anna, if you want to text me through that, I'll have a look and see if I can address some of those questions. My text box is not showing anything. So I'll move on and I'll have another look at that in a few minutes. So we've talked about leave. The other issue that we're getting coming up is, well, what about just varying entitlements, change duties, change start finish times, reduce hours, pay cuts? Those kinds of questions are obviously exercising everybody's minds. Can you change duties? Yes. Clause 8 of the award gives employers rights to change duties within the limits of their skills. So that's something that can and probably needs to be done. In terms of changing start or finish times, it can be done by agreement under clause 18 of the award. And if there's no agreement, it can be done on reasonable notice, which is more than 2 weeks. So we don't have to have agreement there. It can just happen, providing 2 weeks notice is given. If we actually want to reduce hours from full-time to part-time, the award allows for that. There's a few constraints around it. Essentially has to be by agreement and in writing. Just keep your eye on the notification and discussion clause at clause 39 there in terms of consultation. And if there are disputes about that, the disputes resolution procedure will kick in. But essentially where it's agreed, that can happen. Obviously a lot more controversial issues of pay cuts. That's happening in quite a lot of private sector environments. Not sure, haven't seen it in the Commonwealth yet. As far as New South Wales local government's concerned, it'll be tricky if they wanted to do it. As a matter of contract, there would have to be agreement. So particularly with your senior staff there would have to be agreement. If it's not agreed, if a pay cut is not agreed, then technically that's a repudiation of a contract, and that would entitle the senior staff employee to terminate the contract and sue for damages, which would be the notice period, plus their accrued entitlements. The notice period in your senior staff contracts is pretty long, it's 38 weeks, plus accrued entitlements. So I can't see that that's a terribly attractive option for local government. That's for your contract employees. For your award employees, a pay cut below the award level, the only way that could happen lawfully is if there's actually an application to vary the award through the Industrial Relations Commission. But that could happen. The way it would work, there's already noises at the Commonwealth level. The federal minimum wage is up for consideration now. Wage freezes are likely. Whether there be a cut, it's technically possible. It's probably inconsistent with the Commonwealth mantra, but it can happen. But the way it happens, it's not for something that you HR managers would be deciding on the ground. It would be something that would have to go through the Industrial Relations Commission by way of adopting some sort of state wage case decision. But it's possible. So there's flexibility there for duties, start and finish times, and to reduce hours by agreement. I'm just looking at the time. Still got about 15 minutes to go. So I'll just probably remind everybody that my name's Gabrielle Sullivan, and I'm delivering a webinar on behalf of Bradley Allen Love Lawyers in Canberra. We're talking about responses for HR managers to the COVID virus. We're up to the part we've been talking about variations and leave. We're about to talk about redundancies and termination. So the way redundancies and terminations will work, really have to consider the position of your award covered employees, a little bit different to your senior staff who are covered by contract. So as for your award covered employees, if there are to be redundancies or terminations, you must remember the consultation clause there at clause 39, which requires a fair bit of notice where it's disputed. So you'd really want to, if that's imminent, then there should be some consultation happening now so that you don't breach that clause. I know the City of Sydney last week made a whole range of casuals redundant, or attempted to do so. That's before the Industrial Relations Commission now. As far as I can see, the concerns relate around consultation and failure to invoke that consultation clause. So I'm not saying not to do it, I'm simply saying make sure you comply with the consultation clause. I must say on my reading of it, it's not at all clear that it even applies to casuals, but no doubt that's what the decision in ASU and City of Sydney will consider. As I said, that's before the Industrial Relations Commission now. Let's wait and see what happens. There's a whole flurry of decisions before the Industrial Relations Commission in the last few days that have yet to be determined, but watch that space, because that might give a fair bit of guidance as to how that needs to proceed. Assuming you have consulted in accordance with the clause, then what's it going to cost? What are the benefits that are payable on termination? The answer is kind of a lot. Obviously, you need to pay out their accrued entitlements to long service leave and annual leave. You need to give them actual notice, or if you can't give them notice, then you give them payment in lieu of that notice. So that's if you can give them the actual notice, like time, then you don't need to give them the money. So there's some, but either way, they either get the time or the money. If you're going to make more than 15 people redundant, you need to notify Centrelink in accordance with the award. They'll also get, in addition to their accrued entitlements and notice, they'll also get redundancy pay in accordance with clause 40 of the award. And it's a pretty decent entitlement, by certainly above the national standard and above the Commonwealth standard. Go and have a look at clause 40. You're probably all familiar with it. It's a sliding scale of redundancy pay, somewhere between 5 weeks and 34 weeks pay, depending on how long you've been there. Obviously, anybody that hasn't been there for 12 months is entitled to anything. Those people would be obviously cheaper to be made redundant if it had to get to that. And probably just point out that where redeployment's possible, redeployment at level, then redundancy pay is not entitled. There's no entitlement to redundancy pay. So if you do have, if you need to redeploy from one area of service delivery to another, then you should be obviously making those offers within the flexibility and the other provisions of the award that I discussed. If people are unwilling to accept that, then they're not going to get their redundancy pay. So that's the situation for award covered employees. So you can do it. It's just going to cost a bit. And that's obviously part of the whole problem. So you might want to explore the other options, the options I've discussed before and one of the options to come. But I was just talking about your award covered employees. Probably should just also mention for your contract employees, so your senior staff contracts, then you need to terminate, if those contracts are to be terminated, they have to be terminated in accordance with their express terms. They provide for 38 weeks notice plus their accrued entitlements. So obviously there's no quick efficiency wins there either, other than by agreement. But you know, if people want to agree to less as a matter of contract, that's a matter for them. But strictly speaking, why would they? That's what they're entitled to. And if there are to be dismissals of senior staff, the local government would require that the general manager consult with councillors on that fact. So it's just something to think about there if it gets that drastic. Now, as I say, it's going to be expensive to make people redundant. There's flexibility, but there's handbrakes on flexibility. What's going to happen if we get to a point where we can't afford to terminate them, but we just don't have the revenue to sustain them? Well, everybody's talking about this, and that's stand down. I just wanted to finish by just explaining what stand down actually is, so that you might be a little bit more informed. There's a fair bit of a lack of clarity around what it means. So a stand down is the employer suspending performance of the contract on the ground that there's no useful work because of any act or omission for which the employer is not responsible. So it's not a termination. What a stand down does is it keeps the employment relationship on foot and intact. There's no termination, there's simply a suspension. Everything's in abeyance. The reason it's attracting a lot of attention, definitely in the private sector, is because when somebody is stood down, it's unpaid. So it doesn't cost employers anything. So obviously that's a hugely interesting provision. The way it works, federally, the Fair Work Act has a fair bit to say about it. But so a lot of the noise you're hearing about, say, Qantas stood down all their staff a couple of weeks ago, all that, the tests used there are not relevant to local government. Your provisions are regulated by the New South Wales Industrial Relations Act. There, go and get Section 126 out and have a look at it. Basically, there has to be no useful work for which the employer is not responsible. Now, I don't think anybody's going to argue that the employers are responsible for COVID, right? So that second limb of the test is satisfied. No useful work. It might be not. It doesn't mean just your duties. It can mean no. You have to look further than that. Look to other duties before it can be said that there's no useful work. But if we do get to that point, the way it needs to happen for local government is that you can't just stand down your workers. You have to make an application to the Industrial Relations Commission. The Act says that they'll try and process those applications quickly. As I said, there's a range of applications before the New South Wales Industrial Relations Commission right now. I can't see what they're for, but I assume they're for this. And the Industrial Relations Commission will have a listen about, is it true that there's no useful work? Is it true that the act or omission wasn't something the employer was responsible for, and really what's the plan. The examples I've seen of stand down to date, I haven't seen any for pandemic yet. I think they're coming, but if we look at other precedent, the Industrial Relations Commission New South Wales tends to make conditional orders, so they'll say yes, as these people can be stood down for this period or these conditions. For example, the conditions may be that they exhaust all their paid leave first, or that they're entitled to get a second job for the duration of the stand down, things of that nature. What I have seen in the stand down space to date, both federally and at New South Wales level, is that they really want, commissions really want consultation with unions and their staff in relation to these really painful decisions. So make sure that the consultation provisions of the award there at clause 39 are invoked. So I really think you should be engaging in those discussions ASAP, at least to get some consultation on the board, even if it's not a final decision, but it's something that we're thinking about. So that kind of brings me to the end of the substance of the material. I might try again and see how my questions are going. I've got a little, oh, hang on, I've got plenty. just give me a minute. Have a look at the fabulous Bradley Allen Love's 40 Marcus Clark Street building that we're not in at the moment, while I see if I can answer my questions. I'll have another go at that, and if not, let's have a look. I'll move towards wrapping things up. Just bear with me a moment. Okay, so if you're still with me, it's Gabrielle Sullivan from Bradley Allen Love. Just wrapping up our webinar on HR responses to the COVID crisis for local government. I am able to see one or two related questions. I'm just going to tackle that, and then I think we're a little bit close to time. But one of the questions was about, somebody's asked about working from home. What happens when an employee says the employee wants to work from the home, but the employer doesn't want them to? And a second question is the inverse. What happens if the employee wants to be at work, but the employer wants to work from home? What do we do? Now, the answer to that is it's for the employer to give lawful and reasonable directions to their employees, and they're obliged to obey. That's part of one of the implied contractual terms that I talked about right at the start. Employees have a duty to obey the lawful and reasonable directions of the employer, and that applies to everybody: contract staff, award staff, every employee. So we can't really have a situation, can we, of employees deciding what they think is best, assuming our decision makers are making prudent decisions and that they're following the health websites. Then my view is that employers should be definitely about, if they think it's not safe for the employees to be at work, then they shouldn't be there. And the fact that the employee wants to work, too bad, I would be directing them to get from home. And as for the inverse situation where the employee feels that it's unsafe, then the question would be, what's the basis for that feeling, and isn't it reasonably grounded? Because if it is, then you would respect that, right? If it's not, then you issue your lawful and reasonable direction, say, no, you're doing this, right? You're off to the depot, it's safe, we're doing it. So that's how I would recommend handling that. As with most legal problems, it's usually more nuanced than that, and probably need to dig into the facts to get to the bottom of it. But essentially, that's what's happening. It's a couple of minutes to 11, so there are some more questions there that I'd very much like to dig into. That, as I said, I'm a little tech challenged in that. If there's some common themes in it, we'll send that out to you. We're going to send a copy of my presentation to you. If there's any questions that I think it'd be helpful for me to answer, I'll tack those onto it and send it out to you. Otherwise, I think I'm going to wrap up for now on behalf of Bradley Out on Love. I'm going to let you all get back into it. It's a really busy time, isn't it, for HR managers? So all power to you. And if there's anything you think we can do to help, my phone number and whatnot's there on the presentation. You've probably got my email. Drop us a note and we will try to give the most practical, cost-effective and useful advice to you that we possibly can. But it's been a pleasure. I'm going to wrap it up, and I really look forward one day to meeting you in the flesh. I should say I'm from Young. I'm a country girl and I love the country, so very much looking to re-establishing our road trips and seeing you in person one fine day. All right, everybody, good morning and goodbye.